We are now ready to proceed to the panel sessions. Session 1 and 2 will be moderated by Mr. Takatori. We are also honored to have 4 distinguished professionals in the field of international arbitration and international mediation as panelists of the sessions. Now, I would like to introduce the panelists. From your right, Dr. Nicholas Began from CMS. Mr. Began is a managing partner of CMS Hong Kong office, as well as the head of CMS Dispute Resolution Group. Mr. Chan Len-san from Duxton Hill Chambers, Singapore. Mr. Chan is a senior counsel and a chartered arbitrator. Mr. Takatori is the moderator. Professor Yamamoto Kazuhiko from the University of Hitotsubashi. And finally, Ms. Maeda Yoko. She's an attorney at law admitted in Japan and New York, and a partner of the CTUA Partners. In session 1, we will be discussing the use of international arbitration and mediation, and collaboration between them towards realization of the rule of law. As I announced, a material of the panel sessions is posted on the official websites of the Ministry of Justice and the JCAA. Please note that the online chat and Q&A systems are not available. I now ask Mr. Takatori to moderate the session 1 for us. Mr. Takatori, the floor is yours.
Thank you very much. It's a very honor for me, and also I'm very, very excited to have such distinguished speakers, including from the overseas, from Hong Kong and Singapore. So, but we have a quite short timing, so let's move on to the discussions. The first topic is the use of international arbitration and the mediation and the collaboration combination between them towards the realization of the rule of the law. Then we have some subtopic we've set. How to proceed with the ARB-Med-ARB by JCAA and its rule, which is already some explained, but the legal and the practical effect, including the process and the concrete measures to overcome possible issues. So I'd like to first invite the Professor Yamamoto Sensei's comment on this.
I'm Professor of Civil Procedure and ADR Law of Hitotsubashi University, and also Director and Chief Arbitration and Mediation Officer of JCAA. I will talk about the importance of mediation and the benefits of ARB-Med procedure. Mediation has gained increasing attention in recent times due to the shortcomings of arbitration in international commercial dispute resolution. Issues such as process delays and high costs associated with arbitration have become evident, leading to a growing interest among conflicting parties. This is a reason why the Singapore Convention was signed within a relatively short period. The Convention enables member states' courts to provide remedies for settlement agreements resulting from mediation in the same manner as arbitral awards. The Singapore Convention has the potential to enhance the efficiency and attractiveness of mediation, promoting its practical use. Japan has traditionally recognized the importance of mediation in conflict resolution in general. The Japanese court mediation system has a century-long history, and now over 160 private sector alternative dispute resolution organizations certified by the Ministry of Justice actively engage in mediation. As a result, Japan has supported the creation creation or legislation of mediation system in Indonesia and other countries. Therefore, the current trend of positive utilization of mediation in international commercial fields appears natural to the Japanese. Parties can directly request mediation, but they can also voluntarily shift from arbitration to mediation during the arbitration process, a practice known as ArbMed. This transition offers several advantages for both parties, including time and cost savings, preservation of business relationships, and the assurance of predictable conflict resolution. However, a weakness of mediation has been the lack of enforceability, as parties had to obtain an arbitral award based on the settlement agreement to make it enforceable. This could increase costs and complexity. Ratifying the Singapore Convention resolves this issue by allowing settlement agreements resulting from mediation to be enforced through court decisions. Consequently, providing an effective ArbMed process has become more important for arbitration institutions than before. The JCAA has handled numerous ArbMed cases in its arbitration proceedings, supported by comprehensive ArbMed procedures outlined in its commercial arbitration rules. Article 58 of the JCAA commercial arbitration rules allows parties to agree at any stage of the arbitral proceedings to refer the dispute to mediation under the JCAA's commercial mediation rules. The JCAA has a separate set of commercial mediation rules consisting of 35 articles providing parties with a reliable mediation process. JCAA's ArbMed proceedings offer various advantages. Firstly, the JCAA has a unified arbitration and mediation sector, ensuring consistent support throughout the ArbMed process. Secondly, parties can agree to appoint an arbitrator assigned to the dispute as a mediator during the arbitration proceedings, as stated in Article 59 of the Commercial Arbitration Rules. Thirdly, when an arbitrator is appointed as a mediator, parties are not required to bear an additional administration fee. As a result, parties can smoothly shift from JCAA arbitration to JCAA mediation with the goal of reaching an amicable settlement. In practice, arbitrators are appointed as mediators in JCAA ArbMed cases by the agreement of both parties. Since 2014, when the JCAA arbitration rules were amended to include more detailed provisions on ArbMed procedures, in the all ArbMed cases, parties agreed that arbitrators were appointed as mediators without exception. It is worth noting that in these cases, except for only one case, parties have successfully reached a settlement agreement through mediation. In that exceptional one case, both parties did not request resuming the arbitration proceeding, and the arbitral tribunal decided to terminate the procedure. Therefore, JCAA has no experience about the real ArbMed cases. Firstly, one of the main advantages of arbitrators serving as mediators is the efficiency of the process. As arbitrators already possess a deep understanding of the case, the arbitration parties do not need to explain their positions from the beginning in the mediation process. In the JCAA ArbMed cases from 2018 to 2022, the average mediation period was 2.7 months, reflecting the speediness of this approach. Secondly, appointing arbitrators as mediators allows for the possibility of a suitable settlement. Mediators who are already well-versed in the case can prepare and present settlement proposal tailored to the specific circumstances. Thirdly, from the standpoint of the parties, this practice provides greater foreseeability of the result, considering that the mediator will return to the arbitrator in the event of failed mediation. The parties can make a more accurate comparison between the outcome of mediation and the potential outcome of arbitration, as opposed to having a separate arbitrator. However, it is essential to acknowledge the demerits of this practice as well. Firstly, concerns may arise regarding the violation of due process. If mediation fails, arbitrators may utilize the information obtained during the mediation process. In such cases, the other party to the arbitration does not have an opportunity to object to this information. It may violate the due process in the arbitral proceedings. From a mediation perspective, the party concerned about the use of such information in the arbitral award may hesitate to reveal their true intentions or weaknesses during the mediation process. This hesitation to disclose vital information for the mediation can make it challenging to reach a settlement agreement, potentially undermining the success of mediation. This practice has been widely accepted by Japanese lawyers as judges in Japanese courts traditionally preside over settlement negotiations themselves. It is plausible to assume that foreign players would also accept this practice. In the JCAA ARMED process, almost all foreign parties agreed to appoint arbitrators as mediators, resulting in settlement agreements. However, recent criticism of this practice in Japan, due to the aforementioned demerits, necessitates maintaining advantage on the one hand and mitigating these concerns on the other hand. First and foremost, the consent of all parties is an indispensable condition for this practice, as outlined in the model law and JCAA rules. Additionally, the parties' consent is required for the choice of mode of the process, such as adopting caucus proceedings in mediation. Article 59 of the JCAA arbitration rules stipulates that an arbitrator serving as a mediator in the same dispute shall not consult separately with any of the parties orally or in writing without their agreement. It is crucial to respect the parties' role as the primary decision makers in the conflict resolution process and not to deny them options in advance. Secondly, we must uphold due process in cases of mediation failure. It is crucial to ensure that arbitrators do not utilize any information obtained during the mediation process when making the arbitral award. Alternatively, if parties have concerns about due process, mediators should conduct the mediation in a joint session where all parties are present and can address any worries they may have. We must emphasize the discipline of arbitrators in adhering to these principles. It is our responsibility to maintain a balance between due process and the efficiency of the ARMED proceeding. We are confident that these two aspects can coexist harmoniously, and we are committed to doing our best to achieve that goal. Thank you.
Thank you very much, Professor Yamamoto. Let's really appreciate the comprehensive the notes, especially including the costs and the speed and such advantage and some due process issues. The one thing is I'm one of the very heavy users of JCAA as the arbitrator, mediator, and the counsel. So then I would like to invite from the overseas side. Thank you very much, Len-san, for your coming to Japan. And then I would like to have your kind of evaluation of the efficiency of such rules and the proceeding, and from your eyes, please comment.
Thank you, Sensei Takatori. And thank you very much to the Ministry of Justice for inviting me here. I'm grateful to participate in this forum. And I thank Professor Yamamoto for his insightful talk on the ARPMET process, as well as the pros and cons of an arbitrator acting as mediator. I'll just make a comment on that point. I note that Article 59 of the JCAA mediation rules provides that the parties can agree that an arbitrator be appointed as mediator. In Singapore, in law, this is also permissible because Section 16 and 17 of the Singapore International Arbitration Act provide that parties can consent to an arbitrator acting as consolidator, which is the same as mediator. In practice, this is not so often done in Singapore. I think it's a cultural difference. The concern is, as Professor Yamamoto pointed out, that in the course of mediation, parties may disclose privileged information, may show their hands, and they may say something that they would not want the arbitrator to know if there is no settlement. As Professor Yamamoto pointed out, if parties go in to a mediator concerned that they shouldn't be too frank about their position, then that might also endanger the mediation process. I myself, sitting as an arbitrator, have been asked before by parties to act as a mediator. And I'm usually very reluctant to do so because my brain is not compartmentalized into C drive and D drive. So if you tell me something, I can't pack it away in a separate hard disk. But I noticed in Japan, interestingly enough, it has worked. And I think in China it works as well. So maybe it's a matter of adjusting. But certainly from our perspective, it's not often done.
Thank you, Vincent. So, Nicholas, do you have any comments from the website?
I think I can just echo that what you just said. It's very hard to unthink things that you've already thought or heard. So compartmentalizing your brain would be nice sometimes, but in reality, it's very hard to do. So I think that really is one of the key concerns. And I think we're going to talk about the arbitrator's perspective later on again. But that's, I think, a very tough job. And I admire those that can do it. I think it's very, very a difficult task. But I think you just mentioned it is definitely a cultural thing.
Yeah.
That I myself, I'm a civil lawyer as well. Even though I'm speaking here from Hong Kong, I'm from Germany. So I'm very much used to the Japanese approach as well.
Yeah.
But when you look at Singapore or Hong Kong or other common law jurisdictions, they sometimes frown at what we do.
Thank you.
In this respect.
Yeah, observing such kind of a difference between the civil and the common law or something, but there is quite getting few pure civil law corporations or common law corporations. Like many Japanese corporations are quite multi-jurisdictional kind of operation that could be naturally hybrid. And then how to take care of those gap or something could be quite crucial. So then I would like to invite the user's perspective on those proceeding. Like a viewpoint of the arbitrator and the mediator and the parties, and the pros cons as the arbitrator's proceeding practice, such as we talked about the identity of a mediator and the arbitrator, something like that. I'd like to invite the Hyoko's comment as the user side.
Thank you, Takatori Sensei. And it is my great honor to be here as a part of this great panel. And from user's perspective, as already introduced by Professor Yamamoto, I think there are unique advantage of our procedure, because the arbitrator is going to be the mediator. The parties can know what is the impression of the arbitrator on that case, and the parties can kind of consider the weakness of its position, and then can make a decision whether and to what extent they should compromise. And also, because of that, for the same reason, there is a stronger pressure for both parties to settle compared to normal mediation, because sometimes both parties consider that they might lose in the arbitration if the mediation fails. So I think these are the important upside of the Arbit procedure. And when it comes to the downside of the Arbit procedure, I also agree that there are various concerns about Arbit, and I'm a supporter of the mediation in general, and I'm supporter of Arbit. So whenever there is a chance, I propose mediation before or after the arbitration to the client and also to the opponent parties. But the client asks, especially the clients from overseas, will ask various concerns, and most of them are relevant to the effect of what happened during the mediation on the outcome of the arbitration. So it could be something that the other party opponent tells the mediator without the presence of the client, or it could be something that the client itself informs the mediator during the mediation, or there could be the attitude of the client itself may influence the impression of the mediator and arbitrator, because if only the client make huge compromise during the mediation process, that can be seen as a weakness of the client in the entire case. So those are the concerns. And also there are sometimes the client is concerned that even if during the mediation it find out that the mediator has favorable view on the case for the client, the client might lose that favorable mediator after the mediation process because of the challenge by the other party who come to know that the mediator have an unfavorable view on the case. So those are the concerns that are kind of frequently asked by the client. And I think not all of them are very realistic when it comes to an arbitration in Japan or arbitration mediation in Japan or under JCAA laws. Especially the last point that I mentioned is because in Japan, parties cannot challenge the arbitrator on the ground that the arbitrator served as a mediator. For the parties the parties' consent is required when arbitrator serves as a mediator, but for mediators to go back to the arbitrator, the both parties' consent is not required. So the opponent, even if it comes to know that this arbitrator mediator have unfavorable view against it, cannot challenge or refuse the continuation of the arbitrator just on that ground. But just a day before yesterday, I come to know that it is not true in some jurisdiction outside Japan. So in such jurisdiction, probably that concern may be more realistic. And when it comes to the question how to conduct the Arbit efficiently and also safely, based on such concern about the Arbit, first of all, I think it's very important to confirm with the arbitrator who serves as a mediator how he plans to conduct the mediation, because the arbitrator from different jurisdiction could have different mindset about Arbit. So, Japanese parties have certain expectation to Arbit. For example, that arbitrator would disclose its view on the case during the mediation, but maybe not all the arbitrators would do that. And also, there are various difference in how to conduct Arbit, and also there are difference in legal system. And for example, in Japan, there is no without prejudice concept itself. So that means without parties' consent, it could be possible that what happens during the mediation could be used in the later legal procedure arbitration. So, so it is also important to have the same, to explain those differences to clients as well, because especially for the client from overseas, they might have different expectation to Arbit procedure. And lastly, I think it was very interesting that Professor Yamamoto made a comment that if the clients have concern, if the parties have concern about due process, it could be a choice that there is no kind of separate session and just everyone be in the same room and conduct the mediation without separate discussion, and probably that will resolve the concern about the due process. But at the same time, I'm a little bit suspicious whether it could work because there is a higher possibility of, has higher likelihood of reaching settlement because both parties consider they have some weakness. So if the mediation are conducted just in one big room, that kind of tactics for mediator may become difficult. But because of, I think that the concern is there that any information disclosed to the arbitrator mediator may affect the outcome of the arbitration. So in our process, I would advise the client not to disclose sensitive information, not to be too honest. So I think that's almost all that I wanted to cover.
Thank you, Yoko Sensei. Yeah, really interesting the points, including such, a combination of the joint session and the COCA session could be sometimes very efficient as the mediator. So it's a quite tough question. And then, but even under the JCAA rule, I'm, if you get the parties' consent, then you can combine utilize the combination of the such joint session and the COCA session. I understand, and also regarding your point on the jurisdiction, where the when the mediator back to the arbitrator, then maybe that jurisdiction you are talking about, Australia, right? The day before, yesterday we got such information. So then I'd like to invite such how to the overcome such gap difference of the legal culture and the practice, such as without prejudice, something like that. So from the that I'd like to invite the Nicolas comment on it.
Thank you very much. Just very briefly on the very good points you made, Yoko. I think I agree with all of them. I'm also a fan and a supporter of ArtMed, but it has its challenges, especially when it comes to when it's a cross-cultural case. And I think the one point you made is very important. That when you advise a client from Japan or also from, as I said, Germany, where there is no such thing as without prejudice, in a dispute that might be seated in a common law jurisdiction or the other side is from a common law jurisdiction that has a without prejudice concept, I think it's very, very important to clarify that with the client and both sides actually, that how this mediation will play out, how to establish a level playing field, because otherwise you will end up with this awkward situation that one side will be unable or unwilling to reveal their information you in fact need in the mediation to find a good result, and because it's rightfully so concerned that it might be used against it at a later stage. So this cultural difference, I think, is a really key thing to keep in mind. And one more point I wanted to perhaps address is the timing of when you go into mediation within an ARP procedure. I personally made the experience in a dispute between an American company and a German automotive company, where this case was perfect for ARP, or rather, it should have ended with ARP-MED because it was perfect for a settlement. But it went into mediation too soon. It went into mediation after the exchange of the first round of submissions, and both sides flew to Boston. The mediator was actually pretty good. We were there for 2.5 days, but it ended without success because both sides felt like, I can still get more in the arbitration, because they weren't ready yet to reveal everything. They weren't ready yet to really compromise, because they felt, oh, there's another round of submission which will come, and then there's the hearing, so I can do better in the arbitration. So that was an example of where it definitely came too soon. Had this happened after the second round of submissions, maybe just before the hearing, I think that could have been a success. So just to add that perspective of the user's perspective of when to advise a client, now is a good time to actually suggest it. I think later in the proceedings, even though it might not be attractive to a client sometimes, because of course later in proceedings is more cost, but it's also more promising in my experience.
So in your case, what the points were like, fitting to the mediation? That you said perfect for your case. It's what was the points for the?
Well, the points were that I think both sides knew that they had positions that weren't their strongest and where they should compromise, and they were also revealed in that mediation.
And then
they both felt, okay, we're going to lose on that, but we're going to win on that. We might win on that. So it was a dispute with many different points. And that's why I think it's ideal for a mediation, because you can find a compromise somewhere.
They were kind of a business transaction parties?
Yes. Okay. It was a very big dispute between two companies in the automotive sector.
Then pick up the common interest between those guys. Okay, thank you very much. Then move on to the Singapore side. I mean, based upon those discussions, something I'd like to hear from Rensa more about the practical operation and the proceeding by SIAC and SMC, and especially for the operation management protocol by those, and then how to agree upon the ARPMED proceeding and its pros and cons, and then what points should be advised to the other countries and the foreign institutions from a Singapore perspective as the advanced state in terms of the international ideal. So can I ask you?
Thank you very much, Sensei Takatori. When we talk about ARPMED and then ARPMED, perhaps I should start by talking about terminology. I suppose ARPMED means you start with arbitration and then you go to mediation. Whereas ARPMED, which is the protocol I'm about to speak about, is a protocol where you commence arbitration and then you pause it by agreement in the protocol so that parties can go to mediation. And if mediation succeeds, you have a terms of settlement that can be recorded as an award. But if it doesn't succeed, then you go on to resume arbitration. So it's ARPMED. Then you also have a more common clause, which is, I would call MED-ARP, or a multi-tiered clause. I will talk about this in more detail. Basically, a multi-tier clause could be one where parties say we will negotiate in case of disputes, and then we will escalate it if the dispute is not settled to higher management and so on. And if it still cannot be settled by negotiation, we'll go for mediation. If mediation fails, then we'll go for arbitration. So that is what we call a multi-tier dispute resolution clause or a step clause. I will talk about the problems with that in a while, but let's talk about the ARPMED-ARP and MED-ARP. The first thing to note is that when we use these terms, it doesn't necessarily mean whether the arbitrator is the same as the mediator or is not the same person. So when people express concerns, I think it's important for you to express what your concern is, because an ARPMED process doesn't have to involve the same person. And an ARPMED-ARP process, although the protocol contemplates a different arbitrator and different mediator, it doesn't say that it must be that. So what is important is when you agree to it, what have you agreed? Now we come then to the SIAC-SIMC ARPMED-ARP protocol. SIAC, as you know, is the Singapore International Arbitration Center. SIMC is the Singapore International Mediation Center. They came up with a protocol that says that when parties agree to this protocol, once an arbitration commences under SIAC rules, if either party wants mediation, then the arbitrator will stay the arbitration and go for mediation. The mediation will be conducted under SIMC rules, and the arbitrator and mediator will be different persons. Okay? You have 8 weeks to conclude the mediation. If it doesn't conclude, then you can resume with the arbitration. And if you succeed, as I mentioned, then you have an award. Now, what that does is that it means that you do not have to go through all the process of negotiating and mediation before you commence arbitration. You commence arbitration and you stop immediately. So that's one advantage. Professor Yamamoto mentioned that the advantage of an arbitrator being mediator is that you already know the case, so you don't have to explain very long what it is. So I will just take a minute to explain how the process works according to the way we practice mediation in Singapore. I'm also a specialist mediator of the SIMC. Yoko Sensei also touched on that. What normally happens is that parties will submit an introduction of the case to the mediator. When it starts, you'll have a general session with everybody present. Each party will introduce its case and explain its position to the mediator. Then very often we'll have private caucuses. We'll break out to work on the parties separately in private, confidentially. And for me, that's one of the advantages of the way we do it. Because in the private session, you can persuade the party to speak to you very frankly, and you can tell the party that I'm not going to say anything you say to the other side unless you give me your permission. But tell me your number, tell me your position, your interest, and then I will try to work on the other side. So once a party has concerns about confidential information being known to the other party, they may not be so forthcoming. And in Singapore, the way we schedule mediation is we do it usually maximum 2 days, 2 full days. We try to do it within 1 day. If it's not settled, if parties agree, we can do it within 2 days. If it still doesn't settle, what the mediator might do is to say, okay, we can't settle it here, you go away. And this goes to Nicholas' point. At any point in time, if parties feel that they're ready to resume, then come back to me. And I can have another session with the parties. So that's how it works.
Thank you, Vincent. Yeah, that's I hear such quite basically from the common law side practice. Then could be some flexibility, and then from a JCAA side, could be based upon the civil law kind of operation, but could be flexible, including the such sort of a common law style of the operation, something. And I think the strong belief that each institution can learn and get the information quite nicely, like as we are having today's session. So I'd like to invite the Yamamoto Sensei's comment on this.
I have one question. Okay. I have one question. In the Singapore court system, as I mentioned, in Japan, in the court, the judge himself mediate. In the Singapore, is it different?
No, usually there is a encouragement of parties to go for mediation, but there are 2 kinds of mediation. One is, like Japan, is court-assisted mediation, where you can go before someone else who's not the deciding judge. This is in the state courts, in the lower courts, not the high court. So someone else will hear it. But the SICC, International Commercial Court, also has a similar protocol with SIMC. And under this protocol, the Singapore International Commercial Court judge will stay the case and then let you go for mediation before an SIMC mediator.
So you mean for the court, you have a kind of separate judge who is not decision making, but for the SICC, could be some.
Yes, so in the lower courts, they have different people acting as mediators.
Yeah.
Who are different from the presiding judge who is deciding the case. So for SICC, it's the same, except that it's a more formal structure where they refer it out to SIMC under the protocol.
Okay, thank you very much. Okay, you. So then I'd like to hear from the Hong Kong side. I've been practicing in Hong Kong, practical operation management by HKIAC and CTAC, etc. Including the protocol and the rules by those institutions and those effects in terms of the up and up, and then future perspective and points which users should take care of in order to do a business in China, which is quite big interest for the still in the Japanese company, China in Hong Kong, and at what point should be taken care of the for effective utilization of ADR in Hong Kong? Can we have your comments?
Of course, thank you very much. I'm happy to share that. I think when it comes to the regulatory framework for ARP-MED-ARP, Hong Kong is not much different from what you said about Singapore. The Hong Kong Arbitration Ordinance, in fact, explicitly permits ARP-MED-ARP proceedings the way you defined them, that you have an arbitration, that arbitration is suspended, the arbitrator is appointed as mediator, and if the mediation fails, it then goes back to the arbitration proceedings. So the arbitration ordinance, in fact, permits that expressly in its section 33. So it is a procedure known and fully accepted. Same for the institutions. You mentioned CTAC and the Hong Kong International Arbitration Center, the HKIC. The CTAC rules, in fact, in their Article 47, contain a very detailed procedure of how ARP-MED-ARP is supposed to happen, literally quite a substantial provision about how this will all play out, I think more than in probably most other rules. The HKIC rules have a different approach. I think it's in Rule 13.8 or Article 13.8, which basically just says the arbitrator can suspend the proceedings and make appropriate terms on how to continue them as it deems appropriate. And it's generally accepted that under this rule, ARP-MED-ARP proceedings are permissible. So it's two very different approaches that the HKIC rules and the CTAC rules take here. Why is that the case? This goes back to the points we already made. CTAC is mainly a Chinese arbitration institution that is founded on the Chinese tradition of how to arbitrate, how to mediate, and mediation is a very, very dominant form of dispute resolution in China and has a very long tradition, also ARP-MED-ARP proceedings. That's why eventually these already very elaborate and detailed rules made it into the CTAC rules. The HKIC is a institution founded in Hong Kong. And Hong Kong, as I'm sure you all know, is a common law system, and it follows the light touch, hands-off approach of many common law systems, leaving a lot to party autonomy, and also the fact that ARP-MED-ARP, or generally mediation, is a younger idea in Hong Kong and definitely not as established as in China. That's why these rules do not find a specific mention in the HKIC rules, which also brings me to the second point of how is it used, how is it actually lived in Hong Kong. It's permitted under the arbitration ordinance. The two major regional institutions do allow it, and yet it is something that is rarely ever used in Hong Kong. I've practiced there for many years, and I haven't seen a single case where this has actually been employed in Hong Kong. The reason being the skepticism and concerns that I think, Yoko, you've already mentioned, especially when it comes to confidential information. And in this respect, it's especially our section 33.4 of the arbitration ordinance that scares away many users, because it states that confidential information, not just any information, but specifically confidential information, must be shared by the arbitrator before resuming the arbitral proceedings and disclosed to all other parties as much as the arbitrator considers is material to the arbitration. So that is, of course, to many parties a red flag, knowing that the confidential information which they might share in the separate breakout sessions might make their way back into the arbitration on two levels. Of course, you don't want your confidential information, if it's not so good for you, to influence the arbitrator's decision. And of course, you don't want the other side to have it. So there's two levels of concern there that I think prevent a breakthrough of ARP-MED-ARP in Hong Kong. And there's another point that this section specifically triggers. You will have heard that I said the arbitrator can disclose as much as considers appropriate or relevant for the arbitral proceedings. So there's a bit of a discretion left of what or what not to disclose in the arbitral proceedings, which of course, I'm sure all of you as arbitral practitioners will immediately trigger a red flag again. What about enforcement? This is a big risk for enforcement if it turns out that perhaps the arbitrator has not disclosed everything, and then we end up with a disparity of information, which of course can trigger a big enforcement risk. Maybe not so much in Hong Kong because there is a provision safeguarding a procedure that has happened, like an ARP proceedings in Hong Kong from challenge. But of course, if you want to enforce the award anywhere else, you are at a certain risk. So to wrap this up, what's the advice for parties when they do have a case which requires or is suitable for ARP in Hong Kong? I think the first advice is you need to think about who are the parties. Who are you? There's a very difficult question. Who are you? Who is your party? Who are at counsel? Who is the arbitrator? And who's the other side? Who's representing the other side? If you find that the other side is from China and represented by a civil law lawyer, it might make sense to proceed and to suggest ARP proceedings because it's going to be perhaps successful. If the other side, on the other hand, is, let's say, from a less open to mediation jurisdiction, and especially also represented by, no offense to my Hong Kong colleagues, but by a classic Hong Kong counsel or a UK counsel that will frown when you even mention the idea that an arbitrator should put on a mediator's hat and back, then any efforts to try to go down that route might be a waste of time and cost, to be quite honest, because the proceedings might be protracted and very complicated to agree on. So that's why I say the first advice is know who you are, know who your opponent is, and know who the arbitrator is that might be involved in this respect. And then the last point is think about the institutional rules that you're under. Yes, CTAC is very friendly to arbitration, but again, with no offense to colleagues at CTAC, it's still a mainland Chinese institution. And if you have an international case, it's definitely preferable to go for the HKIC rules, which are also give you a bit more leeway in designing the entire process. Or, and I think in this context quite relevant, why not the JCAA rules? If you have an arbitration with seat in Hong Kong, doesn't mean you have to go for HKIC or CTAC or ICC. You can, of course, also go for JCAA rules that might be particularly interesting for parties from a civil law jurisdiction, or from, of course, from Japan itself, in your disputes with with a Chinese party to have a seat in Hong Kong, but under the JCAA rules. That's of course possible, and will give you a framework which might be more known or more familiar to Japanese parties. So that's what I would consider as points to.
So thank you, Nicholas. I hear that the under a common law kind of proceeding in Hong Kong, maybe the mediation usually tend to be a kind of a facilitative kind of negotiation style rather than the evaluative type of things. But in terms of the speed and some corporations, as you said, who you are, I mean, the Japanese corporation would prefer some kind of evaluation for getting the management approval or something. Then that could be some hybrid type of the mediation, and that's kind of a hybrid type. Is not, of course, the prohibited. And that's fundamentally based upon the party's autonomy, right?
Correct. Yes.
And HKIC has such arbitrators list and the mediators list, and then that could be the resource.
Absolutely. HKIC has a very good panel of arbitrators, and I was on the HKIC appointments committee myself for a long time. They do choose and pick the arbitrators that, as you said, might be suitable for a case like that, where they need the background to understand what a Japanese corporation will require in a dispute like that. Yes.
Yes, you have a good list, as JCAA has good list. And then I'd like to invite the Yoko Sensei's comment on those Hong Kong proceeding.
Yes, I found that the requirement under Article 33(4) of the arbitration ordinance in Hong Kong is totally the opposite of the practice in Japan. That in Hong Kong seated the arbitrator must, before resuming the arbitral proceedings, disclose to all other parties as much of that information as the arbitrator considers is material to the arbitral proceedings. So, and to the contrary, under the JCAA rule explicitly provides that the arbitrator does not have to disclose what it heard from one party to the other party. So that is totally opposite. And I think that the difference probably comes from the trust. If I can borrow the example that Ring-san just used, whether the mediator can divide his brain into C drive or D drive and D drive. And I think in Japan, users considers yes, they can, and maybe in Hong Kong or in the common law jurisdictions, users may consider it's impossible. So I think that fundamental difference in the level of trust in the arbitrator and mediator is interesting, and probably it is just my personal guess, but it may come from the parties' trust in the judges. It might come from there, because for a long time the judges have used that tactics, and I think the users felt that it works well, and C drives and D drive separation can work. So.
Thank you very much. Yeah, and very interesting. And then also depending on that case, the nature of the case, then should be figure out what kind of procedure could be the most fitting, as Nicholas mentioned, like more fitting to the possible settlement something. So we'd like to continue, but unfortunately the panel 1 session's time limitation is already expired. So and then step to the panel session 2. So the Professor Yamamoto, thank you very much. Then Mr. Professor Kakiguchi is showed up on the stage. Thank you very much, Yamamoto Sensei.